Too often I hear clients saying, well, I just thought I signed a standard publishing agreement. When you're handling your copyright, everything can be negotiated, which means do not listen to anybody who says, this is standard, this is standard. Hi, welcome to this segment of Organist Launchpad. My name is Jeff Young. One of the things that I do is make music professionally. I'm a screen composer, music producer, and audio recording engineer. One of the other things that I do professionally is practice law. I'm an entertainment lawyer in Canada and in America, and I'm a trademark agent in both countries as well. In total, I've probably practiced by now about 35 years, and I've had the pleasure of representing artists that have won Grammy Awards, actors that have won Oscars, and I've seen a lot of law in the entertainment world throughout the years. Today, I'm going to talk about an introduction to music law and things that will help all musicians understand the legal framework around what they do a lot better. All right, we're going to refer to a series of slides that will complement everything that I'm talking about. And the first thing that we're going to talk about is the basics of copyright. Mostly, I'm going to talk about things that matter to most of us that create music. The first thing is that copyright itself only covers 4 original things. One of the things that a lot of people don't realize is that you can't protect ideas. Mere ideas are not protectable under copyright law. So if you come up with the concept of writing a sappy love song for your significant other, you can't protect it. But if you fixate that concept into specific lyrics and melody, then you have something that you can protect. So copyright law governs 4 types of original works. Musical works, which are melodies, certain non-melodic rhythmic patterns. Now I put a maybe in the slide there because in the old days, you could never protect only rhythmic sequences, but nowadays with people who make beats and make sounds, there's new law that's developed that changes that, at least a little bit. Artistic works. Things that fall under this category are paintings, drawings, sculptures, and photographs. Dramatic works, plays, movies, scripts, and things like that all fall under dramatic works. And then there's literary works. Poems, lyrics, books, and computer software all fall under literary works. Copyright also protects the following additional works. Performances. Even if you perform a public domain piece of music, your performance has a unique copyright attached to it. That means if you create your own version of a song that's in the public domain, that will have separate copyright protection. A sound recording of a work. Once again, even if the work has fallen into public domain, or it's a series of sounds that may not form a melody and may not actually become a melodic musical work, the sound recording itself has a separate copyright. A communication signal also has copyright. So for example, if you broadcast a concert of you performing music, that has a separate copyright as a communication signal. And then copyright also protects derivative works. Many who create music have heard that you can get a copyright protection on your arrangement of a piece of music separate from that piece of music. And that's in fact correct. There has been copyright protection rendered on original arrangements of things like the national anthem. The national anthem itself is a work that's not protected by copyright, but your particular arrangement is. So if you created, say, for example, a unique 5-part vocal harmony version of the Canadian national anthem or any other national anthem that has fallen into public domain, you'll find that that itself is protected. One of the really important principles that you should keep in mind is if you created something, then you pretty much are sure that you own it. There's a few exceptions, but it's important to note that copyright is established in Canada by creation. You don't specifically need to register the work to own it. The copyright itself vests just because the Copyright Act says so. And in most countries worldwide, it's the same thing. And so what happens is that many countries have joined international treaties and conventions, and copyright that's created in Canada is protected in all of these other countries. Most of the European countries are covered by these treaties, and of course, the United States of America is covered by these treaties. So you can actually feel comfortable that if today you create a piece of music, that piece of music is covered worldwide. Copyright lasts a certain number of years, and right now, under certain treaties that we've entered into, the time frame is roughly 70 years after the death of the last remaining author of the work to about 120 years. I would say that a safe guideline when you're discussing these things is the 7-year mark, but if you're actually trying to clear a copyright protected work for use in the form of a license, especially if you're going to use that work in, say, a movie or a video or something like that, then you have to be much more careful. In those cases, it's strongly recommended that you actually retain an entertainment lawyer to do that clearance for you, which is what pretty much happens on all films and TV shows, and there's an entire process that we can engage in to do that. There's also other things involved that affect copyright. You have things like parody and satire, which sometimes may give you certain rights to use music without clearance. But again, it's probably not a smart idea to try to figure these things out on your own. Getting proper legal advice is important. You can also sometimes use concepts like fair use and fair dealing. Fair use is something that is an American legal doctrine. It actually doesn't appear in Canadian law. And conversely, our Supreme Court of Canada, under Canadian law, has commented extensively about when you can use a copyright protected work in the context of fair dealing. So as a creator, you have to be aware that sometimes you may, particularly if you have a musical piece that's become famous enough, have to deal with people using your piece under fair dealing. On the other hand, if you want to create something that involves fair dealing in the form of parody and satire, you may, for certain presentations, be able to use other copyright protected work to do those things. There's also something called the public domain. A lot of people have ideas about the public domain that isn't quite correct. What's important to realize is that the public domain affects things differently if you consider things like derivative works. So for example, if you want to redo your own version of a piece of music that you believe has fallen into the public domain, it may very well have. For example, classical composers like Beethoven have written things, and you could definitely reuse or make your own arrangement of those pieces and not have to pay a royalty. But if you were to choose to, say, use a recording made last year by a symphony orchestra, and that recording was an original work that was based on an original arrangement, you would actually end up not being in violation of copyright for reproducing or using that piece of music, but you would actually have a problem with the fact that you may be reproducing the sound recording, which was only made a year ago, because 1 year is definitely a time period where the recording has not yet fallen into the public domain. So you've got to be careful to recognize that all these different layers of recording and copyright exist at different times. You may be dealing with things like sampling, replays, interpolation, mashups, all things that are part of the digital age. Most of these things that you choose to do will likely, if it doesn't infringe on the actual composition, which would be in most cases the melody and the lyrics, likely to infringe on the rights of the sound recording. When we start looking at the areas involved in music publishing, we're going to see that that's a very important distinction. There's claims about infringement. It's important to know that when you're alleging infringement, or if you're being accused of infringement, that there's certain legal rules regarding time deadlines and time delays that could affect you. In Canada, most of those things, if you're alleging infringement, will show up in an action that's in the federal court, because copyright is an area of federal jurisdiction. So when you're dealing with that, again, it's important to get correct legal advice, but to be aware that if you're involved in any of these issues, then you should be very aware of time periods. There's this thing called Creative Commons. That actually is something that gives rise to a lot of misunderstandings. Creative Commons really is something that you choose to agree to if you want. There is no one that's going to impose Creative Commons on you. Everything that has been put into a Creative Commons structure is done because the creator has actually consented to their work, which they would otherwise own for that life plus 70 years. They've said, well, despite my rights, I'm going to put what I created, which I have the right to do, into the Creative Commons system. And then you get to license the Creative Commons work based on the actual terms of use that appears on the Creative Commons website. So different people will choose to contribute, much like, how much do I want to contribute to, say, a charitable cause, or how much do I want to spend on a movement that I believe in, any of these things. It is the choice of the creator to put forth that work, and then you as a person approaching the Creative Commons website would read the various terms of use and decide if any of those terms work for you. This requires you to actually really pay attention to how the Creative Commons systems work, because each license in the Creative Commons world works differently. When you take a look at the website, some will say, if you want to use my musical work strictly for promoting a nonprofit organization, that's okay. But then if you start taking that work and start promoting for-profit products, that's not allowed. And then other people are going, use it any way you wish, just pay a flat fee or pay no fee, and so on and so forth. So being aware of the license terms contained in Creative Commons is very important. One thing that I said earlier, which was that when you create it, you own it. Well, there's a big exception to that. And that is when you're in an employment relationship. And by that, I mean an actual employment relationship. You're not an independent contractor, but you're being hired as an employee in the sense that you're paid a paycheck, there's deductions, and you are an employee in law of an employer. An example would be, at one point in my life, one of the things that I did in the audio engineering side was to mix audio for major video games. And those composers actually had jobs being in-house composers at major video game companies. They were employees. In that case, then those works which are commissioned are the property of your employer. So the moment that you're in an employment-employer relationship, you can sort of take the general rule that you as the creator are the first owner of your copyright and throw it out the window. It's probably likely that your employer in law will automatically own that work. So one of the things that I have been asked about is in the context of people who are most likely to be viewing this and going, does this mean if I'm working for somebody, I show up on Sunday morning and I'm improving or creating original works for my church, for my service, does that mean that my employer, being my boss in law, automatically own the music? The question is, and it's not to be difficult, but it's sort of a typical lawyer's answer, is maybe. What the Copyright Act specifically allows you to do is be clear in writing about who owns what in that context. I, for example, have mixed a number of major video games where I'm not doing any law. I'm just being the guy that sits at the board and mixes sound. I have a giant 4-paragraph clause that actually says my video game company owns absolutely everything I do. And in Canada, that would be under a concept called working under a contract of service versus a concept of having a contract for services. The former is about an employment relationship. The latter is about an independent contract relationships. So I do a lot of teaching. When I create curriculum, I own that curriculum because it's a literary work which falls under one of the areas of copyright. What I do, because I'm also an employee of various universities and colleges that I've taught law in, is I create a specific clause, and it could be as simple as an exchange of email or a simple addendum to my employment contract that says, for confirmation, any original music that I create is only licensed to my employer as part of my employment contract. It is not forfeited or permanently assigned. No ownership is passed. And those types of clauses are not that hard to get if you have a good relationship at the beginning of your relationship. What you don't want to do is leave it for doubt and then have somebody argue when something happens with that creation that's worth something. So for example, in my case, I've actually been able to sell educational curriculum, so I'm very careful. And it's not a song, but it actually has value. For yourself, if you are a person who creates original music and you believe that your relationship is one where that'll happen, the smartest thing to do, and many provinces in Canada, if not all of them now, and many statutes have a thing that is called the Electronic Transactions Act or something similar to it. And that allows you to do a simple email where you confirm this understanding, and then you get an email back from your boss saying, we confirm, we understand. And that would be enough for you to protect any potential of works you create that are original that you want to hang on to. One of the other things that we have to consider is Section 32.2 of the Canada Copyright Act, which says no religious organization has to pay any compensation for live performances, for a musical work or a sound recording if they are acting in furtherance of a religious, educational, or charitable object. However, this section, even though it seems very wide, was limited in a 1951 case decided by the Supreme Court of Canada called SOCAN versus Western Fair Association. In the fourth edition of his quintessential legal textbook, Musicians and the Law in Canada, Paul Sanderson commented on this case as follows. The Supreme Court of Canada has interpreted this subsection to forbid the making of a profit by anyone involved in the performance. Thus, it is not enough that the event is non-profit, neither must the performers make a profit. Because of the Supreme Court of Canada case, we have a situation where we pretty much know that an unpaid Sunday school teacher, say, leading a rendition of a song like Blowing in the Wind with their Sunday school students would not attract any liability. But on the other hand, we also know that if you bring in a contemporary Christian act and you do a fundraising concert, say, in the evening of a Saturday night, that would for sure attract the need for getting your proper licenses and for paying royalties. What we're not sure of is what's in between and how, say, a performance of a song during a Sunday morning sermon, but by the pastor who's being paid to deliver the sermon, would be treated. So if you're going to play it safe, you still would need, notwithstanding the section of the Copyright Act that gives these exemptions, the proper licensing involved. Certainly in the course of my law practice, I have actually encountered SOCAN knocking on the door when a charitable organization hires a known band to do a fundraising event, and they will expect that if the band's getting an honorarium or any kind of payment, that they do expect to collect royalties on the musical performances of those musical works. All right, so the slide that you have in front of you divides music publishing rights in a bunch of different ways, and I'm going to go through this chart and explain how it works. The first thing you need to know is the words music publishing does not show up in the Copyright Act. It doesn't show up in the Canadian Copyright Act or the American Copyright Act. So you have this concept that affects all musicians. Everybody talks about music publishing, and yet nobody sees this word in the Copyright Act, so it's very strange. Why? It's because the word publishing itself came from the days when music publishing was something that was kind of a dark business. Many facets of the original entertainment industry were funded by organized crime, and they were using it to launder money and a lot of things like that. For those who are wondering if I'm exaggerating, I'm not. There's a lot of historical books about how early music publishing deals were done. In any event, the term is staying with us, and we have a situation now where most of that is gone, but a lot of the terminology and business structures remain. So when you see the word music publishing, it involves all of the rights associated with a copyright protected work, mostly the composition. And when I say composition, we're really talking about the song, the words and the melody. That's at the top of the chart that's in front of you. And when I say words and the melody, I literally mean that only the words, which are protected as literary works, and the melody, which is the melodic movement that you're hearing with your ears. What a lot of people get confused about is that the composition is an entire different copyright from the recording. So when I'm driving down the street and listening to the radio and I hear a song on the radio, I'm hearing two streams of copyright happening at once. I'm hearing a composition and I'm hearing a recording. Even if you're involved in creating both, don't mix them up together. They are entirely different rights. This chart talks only about the song, which I'll refer to as the words and melody. And those rights are then subdivided between small rights and grand rights. So the top portion of the chart is one set of rights, and the lower portion is another set of rights. Small rights refer to the stuff that is to the right of the chart. We'll talk about that. Grand rights refers to only one type of rights, and that is the use of a composition in a musical theater context. And that is a very specific definition. There has to be some dramatic element mixed in with the song in order for grand rights to take place. The law is very clear that if you're going to create something like a Mamma Mia or Phantom of the Opera or something that's a musical theater stage production, you need to make sure you're licensing grand rights. Don't mix up the word grand rights with broad rights. A lot of people do that, and then you see a license for grand rights. And then as a lawyer, I'm looking at the document going, when are you putting on a musical theater production? People are going, I'm not. Then I'm going, why are you licensing grand rights? Then they would say, well, we're really after all the rights so we don't get sued. And the answer is no, you're thinking more about broad rights, but you're not thinking about grand rights. You should save grand rights for only when you're dealing with dramatical musical theater productions. So imagine, for example, if early publishing deals for songs in the 70s that have turned into musicals like Moving On, Mamma Mia, and everything that's happened now, that is millions and millions of dollars worth of rights involved in musical composition that if you don't understand what you're bargaining for, you may leave yourself out of all of those royalties when the song gets into sort of a vintage age for the song and people are starting to use it for musical theater productions. So that's something to keep in mind. Small rights is not a word that means they're less valuable. In fact, they're arguably more valuable now. But it really is just a term of art that's been used in law. And small rights are divided by two types of rights. One is reproduction rights and one is public performance rights. And those words mean exactly what they sound like. When you're publicly performing a composition, you're not necessarily reproducing anything, certainly not until it's captured on video or in some way where it's fixated. And so public performance rights are handled by organizations in Canada, and it's only one, which is SOCAN. And what they do is collect rights for compositions when you hear the song on the radio, when you hear the song in a movie theater, when you hear the song in a club, in a restaurant, in a fitness center. Any public performance usage of music is handled by SOCAN, and they collect royalties for you on that. Now, if you're playing the song streamed in the privacy of your car or at home, that's a private performance and there's no royalties payable on that. So it's the public performance of a piece of music that's collected by SOCAN. A lot of people will call SOCAN and talk about other licenses. They don't handle them. For you to get permission to make a copy of a musical work, in Canada, you can go to the publisher directly, and we'll talk about how we find that in a moment. But if you want general licenses, one of the easiest ways is to go to the CMRRA, the Canadian Musical Reproduction Rights Agency. and we're going to give you a link here in the video, and you'll be able to contact them. And they have a number of programs where they would give you a pay-as-you-go program if you're making CDs, or there's formulas where if you're dealing with digital downloads, you pay for a certain number of downloads in advance, and then you can refresh your license. Now, one of the interesting things about this is not a place to get a license if you want to take a composition and place it into a video work. In other words, mechanical rights are for your ears only. When I try to explain this to clients, that seems to be the easiest way that I found to say this. Mechanical rights are for reproduction of music for the ears only. If you want to have a composition where you are synchronizing it for the eyes instead of just the ears only, you actually need to get what they call a synchronization license in order to secure synchronization rights. Filmmakers do this all the time, and if you're a composer, that's one of the important things that you want to actually earn money from. Because when somebody presents an offer to you to synchronize your composition to picture, there is no standard rate. With the CMRRA and mechanical rights in Canada, there's a standard rate. It's not sort of a legally prescribed rate, but it's sort of the industry standard. In America, in fact, if you're going to be selling mechanical licenses, there's actually a prescribed rate. So with synchronization rights, you get offered a certain amount of money to synchronize the song to film. So a lot of songwriters end up making a very good living off taking their hit songs, or even just known songs, or maybe even an unknown song, and if it fits the scene and the film's director or producer or the production team wants your song, they have to make you an offer for synchronization rights. That is using your composition for the eyes. So once again, mechanical rights are for the ears, synchronization rights are for the eyes. And then for paper, we have a thing called print rights. And that is the third area of musical reproduction rights that you have to pay attention to, because again, that's a source of money. And so this chart summarizes all the different ways that you can make money from your music in terms of exploiting the composition. Another set of rights that you have to pay attention to, and as I mentioned earlier, it's an entirely different copyright. You've got the composition, and then you've got the recording. The recording is literally the process by which you take a version that you imagine, that you've arranged, that you've gone into a studio and created, and made that recording of it. So each recording is separate, and as we know, a song can be revisioned many, many times, and you can have hundreds of different recordings of the same composition. And so even if the same person is working on the recording of a composition and it's the same person that wrote it, these are entirely different copyrights. And you always have to keep that in mind when you're obtaining rights or when you're exploiting the rights. So if you've created a great composition and you've made a recording of it, somebody could offer to license either of them or both of them. And sometimes, in film in particular, a writer will write a song, somebody will like the recording of the first song, but finally decide that they want their own version of it. And so at that point, you would be selling or giving a license of only a synchronization license, because that involves only the composition. If somebody wants to also use your recording, what they would then do is ask you to grant a master use license. And that, of course, is the master use rights. And that's typically something that if you are a person wanting to use the license, you would find the publisher of that work and then ask for rights to do it. And normally what you discover is you would go to a song publisher who would handle compositions for the synchronization rights, and you would go to the record company for the master use rights. Sometimes it's the same entity, Sometimes it is an affiliate, and sometimes it is the same entity or not. And so you never know if you really are going after two different companies, or sometimes you would go after, say, one record company that owns the master use rights, but you may go to different companies that are handling the publishing rights, because you would have different writers involved in a particular composition. One of the music licenses that I was involved in seeking out for a client once involved the band Kiss, where they actually had a falling out, and they would have 4 different publishers for each of their rights, 25% each with 4 different publishers. And all of them would start asking questions like, how much is the other guy getting? We want to match it. And you end up negotiating concepts like most favored nations, where you're offering a deal to person 1, but then if person 2 gets more money, the other person automatically gets bumped up. And typically, with master use rights and synchronization rights, they're also asking for that equalization factor as well. The master use owners will want the same amount of money as the owners of the composition. So the publisher will want the same amount of money as the record company. And so when you're negotiating, you'll find that those are typical business deals that are out there in the industry you've got to pay attention to. Now, there's roles of business people that are called music supervisors, and they literally specialize in securing rights when you're making a movie or when you're doing things. And as somebody who writes music, one of the smart things you can do with your career is, if you want placements actually in film and in video related works, is to get to know music supervisors, and they may know about a lot more opportunity to use your music in shows than you might know yourself, because they're constantly in contact with film directors, producers, and they would be helping supervise and find songs for placement in these projects. The other part of master recording rights are what we call neighboring rights. Now, neighboring rights, weirdly enough, is something when you're hearing songs that are played on terrestrial radio, there are no royalties given for the public performance of the master recording. So when you hear a song on the radio, you literally are only earning on the side where you're hearing the composition, but you're not earning any neighboring rights for exploitation of the master recording when you're hearing it. That's different in the world of digital. When you hear a song being streamed online, there's actually royalties being paid for listening to the composition, and royalties being paid for listening to the master recording. And that's the difference between exploitation in the digital world versus the terrestrial world. The unfortunate thing is that the per play royalty in the digital world is also much lower. And so there's a balancing factor there, and we read about that in news all the time about how the digital royalty rates are too low for creators, and then you have the flip side where users of the music are saying, well, we're paying a lot already, so on and so forth. The important thing for music creators, though, is that if you want to collect your neighboring rights, you need to register to collect them. And there are a number of organizations that actually are there to support that. There are organizations such as Resound, Sound Exchange, and a whole bunch of those entities that are important for you to get to know in order to collect your royalties. The important thing is that you have a number of different royalties to collect, and the neighboring rights is one of them. So if you're a creator, you're probably going to run into something called a music publishing deal. And there are really actually 3 different types of music publishing deals. The traditional one is where the publisher says, hey, I'm going to negotiate based on a 200% pie. Historically, music publishers always say, well, we're only taking the publisher's portion, not the writer's portion. That sounds good, except of course it was an entirely arbitrary division. It would be really something like a realtor coming to your home and saying, well, I can help you sell the home and make lots of money, but I want to own half the home for doing it. It was a very one-sided way of basically owning music from writers that the publishers never created in the first place. But that's been around, and many traditional publishing deals work that way. There's the writer's share, publisher's share, and the publisher would say, I'm only taking the publisher's share, but then they're basing it on a 200% pie. And so the best way I was able to explain this is in the chart that's in front of you. Then, over time, there would be a modification based on parties that had more negotiation rights. One of the most notable writers that would challenge the traditional publishing deal were people like Neil Diamond and Bob Dylan, who had a lot of control over their songs. And so then you ended up with what we call a co-publishing deal. Once again, it's based on a 200% pie. And so the writers would always preserve their 100% writer share, but the writer's own publishing company would co-share the publisher share with the actual third-party publisher. And that is in the picture right in front of you. And you can see how that's divided up. And then as time advanced and bargaining rights even increased, you would have the writer's share be 100% intact, but then the writer's own publishing company would own 80% of the publisher's share and give only 20% to the administrative publisher. And of course, that was to make the administrator actually earn their money by going out marketing the song and collecting royalties from all over the world when the song got famous. One of the things that's interesting about the use of the word administrative publisher is that the administrative publisher doesn't actually own a fundamental percentage of the royalties. They actually are only administrating, and the contract says that the writers can pull all of it back anytime if they are being serviced and they're not happy with the administrator's work. And that would happen basically on, say you give them 2 years and then they see how they do, and then they decide if they want to renew the administrative contract or not. Small comment right now, there are a lot of things going on in the music industry where, for example, organizations like the Screen Composers Guild are noticing that a lot of people like music supervisors are pushing to own and get into the writer's share. It is something that always has been viewed from creators as being quite important to guard, and it would be worthwhile cautioning anybody who's being approached to give up a piece of the writer's share and basically say no unless they've actually earned it by co-writing that composition with you. One of the things that if you're going to be a screen composer, you need to keep in mind is that you will be offered a lot of sync and master licenses. Remember that if they only want the composition, they should only be asking for the sync license and not a master use license, because of course the master use connects to the recording. And you would get sync and master being offered to you in theatrical film, TV and episodic shows, the streamers, Netflix, Apple TV, and Disney. All the streamers need sync and master for every single project because, again, synchronization licenses connect to the composition for the eyes. Make sure you file your cue sheet to get all your royalties. Cue sheets with SOCAN is the only proper way to track how much your music is being used and how much you're going to make off residual royalties on those compositions. One of the neat things being a composer is to watch your music being used all around the world when, say, a documentary that I've scored music on shows up in different countries in Europe and in Asia and that type of thing. Other uses include video games and advertising. Often those have no royalties attached, so make sure you get a good upfront fee. And of course, you should have separate rights negotiated if your music's going to show up on a soundtrack associated with a project. And the last comment is if you're using temp music for a composition where they actually take music that they're not really supposed to take, but give it to you as a temp score so you can follow along as to what your supposed to be scoring for a film, then make sure that you track all of that and not accidentally leave other people's music in or get too close and end up with infringing on temp music. Very important comment is when you're handling your copyright, everything can be negotiated, which means do not listen to anybody says, this is standard, this is standard. Too often I hear clients saying, well, I just thought I signed a standard publishing agreement. But the reality is that you can negotiate whether you're assigning something or licensing something. You can negotiate whether you do something short or long term. You could negotiate whether something is exclusive or non-exclusive. There should be a huge premium if you're going to license a piece of music exclusively for a project, because it really means you can't reuse that piece of music for any other project. You could negotiate only a small territory or a large territory, and you could negotiate single uses or multiple uses. One of the things I had the privilege of working on, I was one of the entertainment lawyers for the 2010 Winter Olympics when it was here in Canada, in my hometown of Vancouver. And we were licensing on a single use basis on some of the music because it was the Olympics. It was once and we were never going to use it again. So we didn't need in perpetuity worldwide. We certainly needed worldwide, but we didn't need to negotiate in perpetuity. And also be aware that you'll always be asked, if, certainly often asked, but almost always be asked to give a moral rights waiver. And a moral rights waiver is not something you should give automatically. You should really pay attention to whether you're worried or not about your music being used in a way that defaces or creates some taint on your music where it's manipulated or mutilated, as the Act would say, in a way that doesn't meet your liking. So if you're worried about how your music's being used, especially if you're going to sell your music to, say, a royalty-free license house, you may want to look at holding back on moral rights so that your song doesn't suddenly end up promoting a product or, say, a political party that you don't agree with. I was asked about what happens if you want to use music outside of certain organizations. I've been told that for a lot of people in the organ world that you're used to organizations like the CCLI and one license. But there are also other organizations that you can approach. SOCAN, for example, if you go to a thing called their public repertoire, you can look up specific songs and literally type in a song title, and you will find that those song titles will show up. And in there, it actually lists specific names of who the music publishers are and how to contact them by email and by phone number. And in America, there is an organization called Songview that is run by ASCAP and BMI, two of the largest performing rights organizations. And again, by typing in the song title, you can get direct publisher information, including emails and numbers to contact. In addition to going to the known songs at organizations like Songview, where you can, say, find a hit song and type in the actual title of the hit song, who the artist was, and how you can find the actual publisher for those songs. You could also go to royalty-free licensing organizations. I've just put some of these up on the slide for you, but I've used Artlist.io for one of the movies that I was helping compose music for, but we needed to bring in other pop songs for certain scenes. There is a organization here, for example, Epidemic Sound, Sound Ideas, Hollywood Edge, and Music Bed. These are all royalty-free organizations. I'm not promoting any of these. These are just things that I found where they offer a one-time subscription, annual sometimes, where you can use as much music as you want and drop them in to certain products and be able to get guaranteed certificates of license for them so that you can clear the music. I also have one little story in answer to a question about what happens when YouTube does a copyright claim and says, I have a problem with something I posted. Well, I was the composer for this Hallmark movie called The Christmas Ring, And I got flagged on YouTube with a message that looks a little bit like the message that's on the right-hand side of the screen. And it basically says, I used a clip from Hallmark and so on, and I wasn't supposed to. And all that I needed to do was to write back using their own response system and say, hey, I am the composer for the music score for this film, and I have a direct written permission from Hallmark to use that clip to promote myself, and this is my demo reel. And all I did was put in a little clause that said exactly what I've shown you on the slide here, which is that I asked in my contract for that right to grab that clip and post it on my demo reel. It took YouTube less than 48 hours after I showed them the clause, wrote my email back, which really only took me about 6 minutes. And they said, oh, thank you very much, you're cleared. And to this day, my composing reel sits on YouTube without the copyright flag. They were able to lift it right away. So the message there, or I guess the lesson there, is to just make everything really clear in writing, because when you're dealing with music and dealing with copyright, the act is very explicit that things in writing do count, and rights in the copyright world are handled through things in writing. And a small last comment is, these days in writing, it can be based on a email exchange that's considered writing. And so you should keep that in mind when you're dealing with permissions like this. Thank you for tuning in to Organist Launchpad. And of course, being a lawyer, I have to say that this is for educational purposes. If you really need a specific situation addressed, please contact an entertainment lawyer that has specific knowledge of music law.